I'm Attorney Zach Townsend, and I'm going to talk with you today about settlement in divorce cases. It's important to keep in mind that there are two ways to solve any case, and divorce cases are no different. The two ways are negotiation and litigation. Those are the only two ways to solve any case, and those are always the only two ways. When you negotiate, it requires both parties to come to the table, and it requires an agreement to be reached. It takes two. In litigation, it only requires one person to force the issue, because each party has the right to litigate. When you litigate, you're going much more slowly than you are when you negotiate. The judge is involved and has a lengthy to-do list of items, each of which need to be checked off the list before the judge can get to a point of having witnesses called and testimony heard and exhibits submitted for the court's consideration and a decision that's rendered by the judge. That's how litigation culminates, and that's known as an adjudication. That's what happens at trial. Trial is usually undesirable because of the length of time that it takes to get there, because time is money, and because you have unpredictable results. You don't know what you're getting yourself into. It's a real gamble because you're rolling the dice and letting the judge, who really doesn't know that much about you and your family, make very important decisions that are going to affect your family's future. So most cases are resolved by settlement. Settlement is how negotiation culminates. So you get to the finish line either way. The finish line in litigation is the judge's ruling. The finish line in negotiation is an agreed upon settlement. It's usually more favorable to pursue an agreed upon settlement because you have time to review it. You could sleep on it, pray about it, share it with people who you think are smart, or do whatever you do when you have an important decision to make. You go into it with eyes wide open. You never know what you're going to get when you have to litigate. You might have a decision that both parties are unhappy with. Negotiation means that the parties try to make an amicable effort to find common ground on their own, and sometimes the use of a mediator helps facilitate that process. A mediator is a third-party neutral arbiter that sits down with the parties to try to broker an agreement. Lawyers can do this as well, but lawyers are advocates and are biased in favor of their clients. So sometimes it's helpful to have a neutral third party help facilitate negotiation, and that person is known as a mediator. Sometimes mediation is mandatory and required by the courts because the courts have a very serious slant in favor of settlement. That's one of the reasons why the case can take so long, or the judge kicks the can down the road, or punts, because the judge is just hoping that the parties reach some kind of agreement on their own. That's an important part to understand, an important part for you to know when you are deciding really the cost of pushing your case to trial. Keep in mind that nobody is going to get everything that they want, and everyone's probably going to have to compromise. So you can't be rigid and expect to be able to settle the case. You have to be open and be able to work in good faith. Those are some tips about resolving your divorce case by agreement.